Hi, everybody. I'm Jordan Ostroff with Legalese Marketing, and this is Exhibit A Attorneys, where we interview attorneys and other experts across the country to talk about what it truly takes to be the Exhibit A of a successful attorney. Today, I have not one, but two guests, both from Even Up Law. Even Up Law is basically a tech company that tries to even the playing field, hence even up between us, PI attorneys, and the insurance defense companies. A lot of that comes through standardizing demand packets to maximize the value of each PI case. So I've got these two gentlemen on here today to help talk to us about how we maximize the value of all of our personal injury cases. Thank you all so much for joining me.
Thank you so much for having us, Jordan. Really, really appreciate your time.
Yeah, and both you guys have some really great backgrounds. So if you want to take a second, go ahead and fill out that bio a little bit more. While that's going on, everybody, Breezy's going to be dropping the comments. So if you want to connect with Even Up Law and everybody else more, you'll have that opportunity right here.
Sure, I'll get started. So my name is Sam. I'm one of the co-founders at Even Up, along with Ray, my second of third co-founders. I was previously a defense attorney. I did big commercial litigation, and as part of, cutting my teeth, I did personal injury defense work, which led me to get, particularly acquainted with wrongful death cases and other serious dismemberments in PI cases. Before that, I used to work at Chubb in claims. And so I have a pretty good sense of how the defense moves. And I basically left my full-time practice to co-found Even Up about 1.5 years, 2 years ago. And it's been quite a journey since. I'll let Ray give us his background as well before going more into that.
Thank you. Hey guys, my name is Ray. I'm one of the 3 co-founders at Even Up Law. My background's a little bit different. I've primarily been in the tech space for a large majority of my career. So starting different tech companies within education, recruitment. My last company got into 500 startups, a platinum tier accelerator program. So I got to learn from the best minds in the world in terms of growing our business. So yeah, a little bit about me, what kind of connects me to this story here is just, I never actually knew anything about the personal injury space other than my father, who actually got into a catastrophic motor vehicle accident back in 2004. And one of the things that kind of motivates me every day is seeing that we settled for pennies on the dollar through that case and that experience with my family. And, through meeting Sam and my co-founder, Rami, it's pretty cool that we're on a mission to kind of change the story for other people through our product and our services.
Yeah, it's so sad. I hear that story at least once a week. Just like, oh my God, I wish I had called, or this is what happened to us, or, can you guys go in and fix it now? And unfortunately, so many times the answer is no. So I love that you guys are putting that together from the tech space to try and even the playing field. All right, so we're going to talk about how to maximize the value of your personal injury case. Before we dive in on that, I want to talk about our last episode. We had Mitch Jackson on. So Mitch is the streaming lawyer, streaming.lawyer, literally wrote the book on social media and branding for entrepreneurs and other professionals. Talked to us about how COVID-19 has changed the legal marketing and branding space and some things we can do to take a lot of our efforts digitally, virtually, remotely, while still continuing to build a brand. So after you hear the wonderful insight from Even Up Law, if you're concerned about social media and your branding, go ahead and listen to Mitch. But I want to dive in while I've got not one, but 2 amazing guests here on maximizing the value of your personal injury case. So Sam, I think where we need to start, because a lot of people don't know this, even some attorneys, kind of walk me through what happens on the defense side for a case. Because it is scary how much computers play a role in resolving PI cases, at least on that side.
Yeah, so there are 2 ways to break this down. Number one is what happens at the pre-suit, and then what happens when the case is put into litigation. At pre-suit, there's actually quite a bit of divergence on what happens depending on which carrier you're sending your claim to. If some bigger carriers will only look at the CPT codes and assign a specific value that they decide is reasonable to it. And then
I just want to jump in for a second. CPT codes, for those who don't know, if you can expand upon that a little bit.
Yeah, so the CPT codes are basically the treatment codes. Whenever you look at your medical bills, there's going to be a code attached to every treatment. And the value of that treatment is going to be prescribed internally in certain carriers. So a carrier will look at all the CPT codes and will decide what the reasonable value for that is going to be, irrespective of what jurisdiction in which you're in. So there are certain carriers that PI attorneys have a lot of difficulty with. Their approach is just to take the CPT codes, assign a value to that, and then give you an offer on that basis and only that basis. And that's why you have certain instances where you send the demand package, you send in your medicals, and then all of a sudden, and there's no dispute as to liability, and despite that, you get an offer that is below your specials or the medical bills that you've accumulated for that particular case. That's really what happens. Other carriers are a little bit more methodical and a little bit, let's just say, equitable in their processes. They'll look at the ICD codes, which is the diagnostic codes. These are basically the codes that are assigned by doctors when they are treating their clients, as well as the CPT codes. And so what the claim adjuster does, the first thing they do is they read through the medicals and the demand package, and they try to categorize what the bodily injuries were. And if they don't have the ICD codes, they must guess as to what those ICD codes are, and they tend to guess broadly. And what that does is it actually reduces the value of your claim from the very, very beginning. Right. So if they guess broadly, the injury is less specific, less severe, then the software is going to return a lower quantum. Now, the other thing that we must consider for certain carriers is that the injury is not the only compensable element. There are other things like economic damages, and economic damages is not just one thing. It could be a couple of things. It could be loss of household services. It could be economic losses. It could be out-of-pocket expenses. And so it's extremely important that you outline these different economic losses in the body of your demand package, because otherwise you're leaving money on the table. And sometimes you don't have perfect information, and that's fine. And it's worth taking a stab at it based on statistical analysis that's out there as to what the value of this person's loss of household services is.
When you talk about loss of household services, what are some examples of that?
Yeah, this is basically, let's say, God forbid, but let's say someone gets hurt, they can't pick up after the kids anymore, and their significant other needs to do everything for them. This is not technically an economic loss, but it is quantified in a very economic way. So what is the value of their spouse's time in contributing additional time to household chores? And in certain jurisdictions, this also falls under the ambit of lost time. So because of this injury, you are forced to spend your time in a way that you would otherwise not have done. And there's another methodology you can adopt here in order to come up with a specific value as to how much that is worth.
So, and correct me if I'm wrong, you also have this system with the insurance company side where they're looking at, what prior claims you've had, what you've settled for before, your attorney's history, what your attorney settled for before in similar cases. I mean, the data that they're collecting on this is like Minority Report level.
Yeah, that's exactly right. So going back to your initial question, what they do, this all happens on the adjuster sides, right? So they look at all this information, they put it into their system, and the system spits out a number. And then the adjuster has one of two choices. They can either accept this number and negotiate with it, or they can go back to their bosses and ask for a higher settlement band. And for them to go back to their bosses and ask for a higher settlement band, they need to not look like idiots. And so it's helpful to give them the ammunition that they can then utilize to justify a higher quantum. Now, this is all pre-suit. What happens if a case is put into litigation? That's what I would do. I would deal with relatively larger cases. So the reserving process was extremely, extremely important. And the insurance companies were very, very sensitive to how much they're reserving a case for. And what that means practically is that I need to sit down and prepare a case assessment memo, which is comprised of a damage assessment memo and a liability assessment memo. And to prepare my damage assessment memo, I needed to go through and do a verdict analysis. I need to look at the internal data of that insurance company. I need to hire an economist. And this is something that I must do. And oftentimes I found myself not being assisted at all by the information the plaintiff counsel would have provided me. So I know a lot of folks make a religion out of making defense counsel and adjusters as the most evil people out there. But if for a moment we were to suspend our beliefs in how evil they are and to contemplate them as our friends, then you would want to do a lot of that work for them, because it actually reduces their workload, and it makes it easier for them to give you the settlement that you want and to reserve in such a way that you can get to the settlement that you need maybe after depositions.
Makes total sense. Ray, you want to jump with anything before I go to the next question?
Not too much. I just wanted to kind of double click on that point. Not all insurance adjusters are as evil as kind of they're portrayed to be. And so if you give them what they need to get their job done and make their lives easier, then they can give you what you need and for your client to get a better outcome for their case. So.
And faster. I mean, that's one of the things I've seen be the biggest is when you can get all the right information, you can expedite the resolution, even if the case would be worth the same, but it's better to have that money to your client now than 4, 5, 6 months down the road.
Yeah, that's
Exactly.
absolutely right. And I think this was a minor point, a really minor point that I think I had a lot of back and forth with my CEO on that required a lot of technical work for us to wrap up on. But just the practice of properly exhibiting things and making the medical records legible for all parties involved will go an incredibly long way. I know some PI practitioners have a practice of just lumping everything together and just sending it off into the ether, hoping that someone will parse through it in a methodical way. If you do a lot of that work for them, right, you're helping them out a lot. And one of the big pushbacks that we get is a lot of adjusters don't even read this stuff. And fair enough. That's why they created bad faith laws for, right? That's why there is a process through which you can make sure that you are getting, you can open up the policy and get additional verdicts if the insurance carrier is not treating your demands in a fair and timely manner.
Yeah, and tactically, there's reasoning for you from the attorney side for this. I mean, there are cases that we were trying to maximize the value of the entire way through. There are cases where I genuinely don't want the insurance company to tender because it's already worth, like, so I'm in Florida. So the $10,000 that somebody else may have, they might already have $100,000 in bills by the time they contact us. And in those, I'm like, please don't tender so we can get bad faith. And obviously, to the insurance company's credit, they are very good about getting that stuff resolved very quickly in those egregiously terrible circumstances. So I want to back up a little bit and reframe this in terms of what attorneys can do ASAP, or what litigants can do ASAP before suits even filed. Like, what are some things that can be done at that point, or I should say before a demand letter even goes out? What are some things at that point that can maximize the value of a PI case?
Yeah, this is a really excellent question, and I think I'll give you the more common answers, and then I'll give you our particular take. I think that one of the more common answers is around medical management of the client, making sure that the client is treating in a timely fashion, that they're going through all their appointments, and that they are following through with the recommendations of the different medical providers along the way. So that's one of the big things that a lot of really good PI law firms will do. But one of the elements that we really try to push for is pain and suffering and economic damages. If you look at the jury instructions, if you want to be very methodical, you need to look at every single element of loss that is included in a jury instruction, and then make an argument as to how much your case is worth for every single one of those elements in your demand package. I think that the easier version of that is just to try to build up pain and suffering very, very early on. And a good way to do that is to speak with your client and to get those subjective data points from them at different times in the pre-suit practice. What does that mean practically? So when they come through the door of your law firm, ask them what their pain levels are, ask them how the injury has affected their lives. And then before the demand package is sent out, ask the same thing. And this way you have two data points that can substantiate how this client of yours has been affected subjectively by this injury and this incident. And what this does is that it really adds that one or two lines under the non-economic damages piece that will substantiate a higher, that will command a higher premium for that particular claim. And the reason why this is important is because as soon as it's put into litigation, these are the things that defense counsels are going to be particularly attentive to. This tends to be a huge element of any claim, and not building it up earlier on is a huge mistake. One other thing that I think is particularly helpful is getting more information around economic losses. How many days of work did they miss out on? Has this affected their ability to contribute to household chores? These kinds of things are also really, really important. And and what I'm saying, I think sounds very, very difficult because there's an element of subjectivity to it. But we've seen counsel, some plaintiff attorneys having these questionnaires that they have their plaintiffs fill out. So as weird as it may sound, you can intersperse a great level of humanity and subjectivity into your demands by using automated processes. And this is what will make your demand stand out and what will eventually prepare you for a much more robust litigation practice as well.
All right, I want to get into demands in a second. Breezy, when we go through to cut this out, let's cut that segment that Sam just talked about, and let's include the Florida jury instructions so we can get some specific examples as people are going through the smaller ones. The other thing that I always suggest for people, my 2 cents, also talk to family members, because there are those PI clients that are blowing things out of proportion. Those totally happen. But there are those other clients that are trying to tough it out and put on a happy face. And then you talk to the spouse or you talk to the kids and you get a totally different story about how it's impacted them. And so highly, highly, highly suggest make sure you're interviewing the rest of the family to the extent that you can, especially about the economic stuff. All right. So anything else before we get into putting that demand packet together? Because I know like that's the part where you all shine, at least the first part where you all shine.
Yeah, I'd say also having and this is it may sound like super intuitive, but making sure you have all the medical records and bills.
You say it. We have a lot of cases where we're the second attorney tracking down like 1.5-year old bills that nobody else got. So
I mean,
I hear you.
I mean, I can't tell you the number of times where we're working through a demand and we're like, hey guys, like there's like a bunch of bills that are missing here. There's a treatment record. And then the other thing that's really, really important is sometimes there are recommendations for a further treatment in the medical records that are missed by the case manager. And so you had a few instances where there was a potential mild TBI diagnosis that was looming, but that was not followed up on. And that we thankfully caught it and related to the powers that be. But those are, I think, getting the medical bills, the records, making sure you're methodical about that process, and making sure that you're following up with your client to make sure that you have their entire list of providers is going to be tremendously helpful, because it's otherwise going to really slow down the settlement process as well, because the claim adjuster will ask for this additional information.
And for anybody, TBI, traumatic brain injury, so could be what we call a concussion, could be way, way, way worse. So all sorts of things along those lines become huge, especially the sooner they are treated, the quicker people seem to get through the long-term cognitive effects, depending upon what it is. So I love it. And I love the fact that you're talking about like you all catching this, like that second set of eyes becoming huge for a ton of this to maximize the value, but also to maximize the recovery of the person. You know, if they've got this potential TBI issue that's never addressed, who knows how long they're going to have memory fog? Who knows how long they're going to have, emotional fluctuations? Who knows how long they might have blurred vision or whatever else comes up from some of these things that if it's caught quickly enough can get addressed.
Yeah, absolutely. And in our case, it was on the onset of a personality disorder, really, and that could have become a huge impediment to their lives going forward, not only to themselves but to the family members too. So, I think we're very careful about indicting personal injury attorneys about not catching these things. The reality is that they have so much things to do, and the system is created in such a way that they need to go through a large volume of cases in order to make a livelihood for themselves, and for it to be economical for them to process through all the claimants that have a meritorious claim. And I think as you rightfully mentioned, it's often helpful to have a second pair of eyes, because it tends to be unrealistic for the attorney to comb through the medical records themselves to make sure there's nothing missing.
Well, and not only the nothing missing, but also having the necessary knowledge base. Yes, we see a ton of medical records, but like there are cases where even we've brought in, nurses or former doctors or had expert witnesses come in and like review things. And there are things that they'll catch, which they should. I mean, they should know it better than me as a lawyer for some of these things. It's crazy to see, the wording of some things or what things could actually mean. All right, so talk to me a little bit about that demand phase, because obviously I think from a personal injury standpoint, this is probably the most important part. As much as we talk about being trial lawyers, 90-something% of cases aren't going to get to trial. So that demand packet could be the first real true opportunity to get the right valuation. for your client on the case.
Yeah, so actually, I will step back for 1 second. There's
Yeah,
one
of
thing
course.
that I'll add as to what you should be doing to maximize the value of your case. If you do have a very, very big claim, then you should be sending information to the adjuster earlier rather than later, because that is going to inform their process in reserving. So you want the claim adjuster to reserve as high as possible, as early as possible as well. So if the person is going through significant surgeries or has significant surgeries that are scheduled, don't wait until the demand package is prepared. Send that information to the claim adjuster. Make sure that they're aware of the severity of the claim, and then that way they have ample opportunity to reserve appropriately and have the reserves that are proportionate with the demand you're going to be sending in thereafter.
Makes total sense. Yeah, we had a case that actually potentially became a medical malpractice case during one of the surgeries from the personal injury stuff, and we were able to get all of the records there ASAP while we then went to figure out the sepsis or whatever it was after that. And it was crazy to see, like, again, to go back to your original point, the insurance company did a really nice job coordinating with us to limit their exposure on the medical malpractice side, but also to, assist us in getting the case resolved properly.
No, and they tend to do a good job as well, because the claim adjuster doesn't want to look like a fool either. They don't want to under reserve a case, and for a case to be passed into litigation, it's just not a good look for the claim adjuster either. So this is something that they can be proactive about, and that they're happy to do so.
All right, so we've got the economic stuff from clients. We're getting those multiple points of contact with them. We're putting these things together. We've got some records went out. We found the rest of them. We got this demand packet. So kind of walk me through the process of what should happen. Walk me through the process of how Even Up assists with this, etc.
Yeah, for sure. So I like to say that we don't do anything new. We're basically, if you had an extra 7 hours in a day, you could do exactly what we're doing. We just have put a little bit more math and spin to it. But we're doing something that any attorney most attorneys could do themselves. All right. So what we do is we will expose all the relevant information, exhibit it, and add additional analysis to it to make it very, very clear to anyone who reads the demand package that the amount that we're claiming for is perfectly reasonable. And what we do in practice is we go through the facts and liability section. If there's a police report, we take the important snippets and put it in there. If there's property damage that establishes cause, then we're going to put in the pictures in there as well. For medical expenses, we'll summarize what the medical expenses are. If there are recommendations for future treatments in the body of the medical records, we will include those as well. As for the summary of the injuries and the treatments, that's where we're super methodical about actually including the codes. This way, you're sort of putting the blinders on the adjuster and forcing them to put in your information into their system in order to get the value that is attributable to the specific injuries of your client. And we also summarize what each provider did by basically giving a sense of how many treatments there were over what period of time, what was the pain level coming in, what was the pain level coming out, and sort of the prognosis at the end of it. And once this is done, this is sort of the basis of the factual basis upon which you build the damages section. And the damages section also needs to be detailed. You can't just ask for the policy limits. The damages section needs to be broken down into the medicals, of course, but as well as the economic and non-economic damages. For economic damages, we will do the analysis for loss of household services and loss of earnings. So we tend to refer to the Bureau of Labor Statistics for the foundational math that we do in order to come up with our projections. And for out-of-pocket expenses, we'll take all the receipts and expose them in the body of the demand package. For non-economic damages, we have two methodologies. One is we actually do a verdict search and a settlement search ourselves, right? So whenever we get a case, we try to identify the most analogous cases with reference to the injuries and procedures and the jurisdiction of the claim. Sometimes it's not possible to find one that's in the exact same venue, so we find verdicts in a similar venue. And this really, if you're asking for $400,000 in non-economic damages, and you cite to 3 cases that have very similar injuries and treatments, where there was $1 million in non-economic damages, that really clearly purveys that you are being very, very reasonable. And that sort of sets off the trigger for a potential bad faith claim later on. And if we can't find great verdicts, we also do a pro diem analysis. And sometimes we even do both just to show, what we could be presenting to the jury to really push the envelope. What's particularly special about our company is that we try to get as much data as much settlement data as possible. So insofar as there is no confidentiality provisions in the settlement outcomes, we will actually pay the attorneys that we prepared demands for them to share the settlement data back with us. And so that way we're building our internal repository of hyper-specific settlement data with the injuries and treatments and facts searchable, categorized, and highly specific, such that we can have a pulse on what the outcomes for certain cases should be going forward. And this really makes it the more density we have in certain jurisdictions, the better sense we have of whether your staff is overperforming, underperforming, and whether you should be putting more cases into suit because the claim adjusters aren't giving the respect that you deserve.
Well, and let's be honest, as much as you all are putting effort into that, you're at best evening the field to the insurance company. At worst, still behind what the insurance company is collecting. It's just insane to me the not knowledge, the data differentiators that we have between the two sides.
Absolutely, it's not just data, right? It's data and resources. So insurance companies how do they even price insurance? To price insurance, they need to have a methodical way of aggregating and understanding the claims management process, and then adding a markup to that. So they have their own ways of understanding how much these cases are worth, and they also have more resources than the average plaintiff personal injury attorney, and they can wait. So we're just offering a little tool that plaintiff or personal injury attorneys can have in order for them to get the full value of the cases without spending an enormous amount of time on a per case basis. And we're giving them the opportunity to scale up their demands in their practice without having to hire a ton of staff. And on the other side, on the defense side, they'll readily hire economists, they'll readily hire experts, and they pay a fraction of the cost that you pay because they have large deals with them. And so that makes things really, really difficult to balance out as you go forward with mid-sized practices.
Well, and especially you've got the insurance company, in essence, subsidizing those costs across all of their users, whereas the personal injury firm might be subsidizing their against 10 or 15 clients or 50 clients or whatever it is. There's a lot more opportunity there for them to put more money to lessen the amount of money you'll get for your injury.
Yeah, that's absolutely right. And maybe one other point we could touch upon is just the inherent conflict that exists between the policy holder and the insurance company, and how you can position that in the demand package. This is an idea that was espoused by Nick Rowley and Running with the Bulls, and I think it's been widely adopted thereafter. But really making sure that the insured is also reading the demand package, is understanding the demand that you are making, and also understanding that if the insurance company fails to settle within the limits, then they are on the hook for that excess judgment. And that really rattles the insurance company, because now they're getting pressure from two sides. One is the plaintiff counsel, but then they also have the animosity of their own client, of their own insured, pushing them towards a settlement. And what often happens is, in cases of great acrimony, the insured will get their own counsel, and that will take things up a few notches for the insurance company as well.
Is the craziest thing, right? You pay for insurance to insure you, and then it doesn't, and then you need to hire an attorney to defend you because the insurance company won't do what you paid them for. But
have you had any experiences like that, Jordan?
Not where we have been the one who has been brought in, but where we have enjoyed that the other side did bring in another attorney to help them for cases that seem to be a lot easier to resolve than the insurance company wanted to do it.
Yeah, that's beautiful.
So who knows? When it happens. Anything else along in that demand phase? And then obviously we'll talk about after that. But like in terms of getting together that ideal demand packet, anything else you all want to share?
The last thing I'd say is you need to give the insurance company a reasonable amount of time to respond. I mean, the bigger the claim, the more time you need to give them, obviously. And to really think twice for the smaller claims that are obvious, just wins. When they come back and ask for an extension, really ask yourself why they're asking for that extension. If they're just trying to go through additional records to find something to throw out, you have to be very methodical about your thinking with respect to delays and extensions, especially for the purposes of maximizing the value of or the propensity of bad faith claims that come after.
Absolutely. All right, so let's talk about that post-demand packet. So we put together this great demand packet. We've got everything you're talking about here in it. We send it off. We don't have a resolution. So walk me through what can we do after that to maximize the value of PI cases as they continue down towards, filing suit and trying the case.
Thereafter, one trick that I have seen in again at the demand package stage is if you're fairly certain that's going to happen, to just attach a draft complaint to the demand package. And that tends to ramp up the pressure a little bit because they know that you're willing to file suit. And I'd say the one thing I'd say about if you don't get the respect that you deserve when the demand package is sent out, like, don't hesitate to file or to refer the case out, because then the claim adjuster will sense weakness, and it becomes much more a question around playing around your relative position as an attorney versus the merits of the case. So you always want to make sure that your conversation with the adjuster and opposing counsel is squarely around the merits of the case and not around any exogenous factors that may be your practice or your desire to get to a settlement quickly.
Yeah, we had there's an attorney in town that has the, I don't know if it's his expression or somebody else gave it to him, but it's basically F it, file suit. And it's not that it's anything unique, but like I have heard him say that 100 times on at presentations at the bar, online, whatever it is. And like, it's so true. Exactly what you talked about. Like, it, to some extent, there's a game of chicken in a lot of these cases. And if you're not the one who chickens out, you're going to get a better resolution for your clients.
Yeah. The one thing I'll say is if you do put the case into litigation, the counsel will have to read your demand package, and it's worth having a conversation with the counsel then, because they might have a different approach than the claim adjuster does. And that's a very delicate process as well, right? Because counsel has to respond to you, but also has to respond to the adjuster. So you really want to help counsel understand that case as best as possible, as quickly as possible, because, talked to a bunch of Allstate folks. They're fighting with their adjusters just as much as you are, right? They're fighting with the internal stakeholders to get to a settlement as frequently, if more frequently than you are. So if you help them make the correct arguments, you might be helping yourself. Just know that it might be a little bit difficult to settle the case immediately after it's put into litigation, because they may need a few more new facts in order to push the envelope and to get a bigger authority to settle the case beyond what the adjuster had reserved for. But it might not take as much work as you think. So it's always helpful to have a little something in your back pocket to give to the counsel to give them that extra push that they need to get to a higher settlement band.
Well, and also as you go to mediation, I'm a huge fan of like, all right, here's the demand packet. Here's what's changed since then. Now have the mediator read it and then see if the mediator starts, arguing with them about how reasonable this was 8 months ago before we filed suit and went to this stage. So
yeah, for sure. And what we've seen some of our clients do is they have a pre-mediation demand and a post-mediation demand, and they basically have a binder with all the demands that they have prepared throughout the arc of this litigation. And when you send your bad faith notice, that becomes the smoking gun in many ways, because you have an arc, a clear, reasonable arc of demands that have been systematically supported over time and that the insurance company has disregarded. And that's going to make a very, very big difference and an impression upon the insurance company when that discussion around bad faith arises.
Especially also if you're in a state that allows for proposals for settlement or something along those lines, where you can make a formal offer. In Florida, if you beat it by a certain percentage, you can get costs and fees and whatnot added on top of it. So it's really nice to be able to pad some of the bad faith packets with like, hey, could have been resolved for this so long ago, and here's what they got dinged for.
Yeah, absolutely.
So as we get towards the end, any other tips or tricks or insight y'all want to share when it comes to maximizing that value of PI cases and utilizing even up law to help?
Yeah, I'd say the last thing, maybe I'll let Ray as well comment here, but I think the one big thing that I'd say is to spend a lot of time with case managers and paralegals to make sure they know what to look out for and they know what questions to ask their clients. Insofar as as automating processes, we're always happy to step in and help any PI law firm, small, big, doesn't matter, to automate a certain elements of their practice. It could be standardizing the questions they ask at intake, standardizing the questions that they ask pre-demand, and collecting the information for them to actually draft a demand package. All of this is super important, but it always relies upon the case managers doing a really good job. And if the case managers are not doing a good job, it makes this entire process a lot more difficult. And so I would say training is an enormously important element of running a good pre-suit practice, and having experienced people there that know what they're doing and having a second pair of eyes is going to make a very, very big difference.
I also think there's a beautiful customer service standpoint of that, or there's a genuineness of concern when you have that right case manager, that right paralegal who truly cares about the client. You build that better relationship. They get you, the client gets you records faster, or they sign the HIPAA releases faster. They come in to, they review the demand packet quicker and get it back to you to send out. I mean, it's amazing how far you'll go with that better relationship, as opposed to, you get some of these firms with 350 cases on one person and then they don't know anybody. It's just a file number.
Yeah. And what you add to this is just like Sam said, I mean, case managers, paralegals, they're typically like the unsung heroes of the firm. They're handling so much and nobody kind of sees how much is like actually being handled by them, talking to clients, collecting medical records, even writing these demands. And so some of the best firms that we work with actually recognize that, hey, like, okay, we hired these capable people to handle these processes. We need to do what we can to enable them to do their best work. And so the more tools, kind of resources that you give them to stay organized and most of all, stay focused on what matters in terms of working up these cases, that's incredibly important, because like we've kind of harped on this point. What goes into the demand package is actually the most important part. Not just us, of course, we write the demand, but we want to save you time from like actually writing those demands so that you can focus on actually getting, the information that's needed to actually maximize the value of the case. So help your people. That's pretty much the main takeaway there. They're your everything, and that's going to help you scale.
I love it. As we get towards the end, anything else you all want to make sure we cover? I know we'll have our final takeaway, but I want to give you all the floor.
No, I mean, check us out. I mean, we're a legal tech company based out of San Francisco. Our idea is to standardize the pre-suit practice for every single personal injury law firm in the United States. So if you're walking through a PI firm in West Virginia or Miami Beach, you should be getting the same kind of representation. And what we aim to do is build a toolkit for personal injury attorneys to use in order to achieve better outcomes for their clients faster. And we don't pretend like we're going to replace anyone. We don't pretend like we're better than anyone. All we are is more hours in a day. We're, as Ray likes to put it, we're sort of the Iron Man suit for the average case manager and attorney. That's Ray. Credit goes to Ray on that one. And that's really all we achieved to do. And so far, I mean, we raised our seed that summer. We're raising our Series A. Well, we're completing the Series A this year. And our clients have been tremendously happy with us. We haven't had a single customer return, so we've been very, very blessed. I think we've hit a nerve in the market, and we know there are a lot of PI attorneys that are out there that have a bunch of demands waiting to be written on someone's desk.
Look, I want to flip that around. That's a bunch of clients waiting to get the money that they need
That's
after
right.
this accident. That is just waiting and waiting and waiting.
Yeah, and I mean, listen, like. PI attorneys are so focused on getting the clients through the door, and it takes so much effort to get the marketing right. And once that machine takes off, there's often a mismatch between operational bandwidth and marketing capacity. And there is no great turnkey solution. And that's what we're offering as well for the clients, for our clients who are growing and scaling quickly, where they can't bring on staff fast enough. We're the perfect solution for them as well.
Love it. All right. So if you've enjoyed our Exhibit A shows and you love the information we have to share, I want to invite you all to our next episode. That's going to air on September 20th at 1:30 p.m. Eastern Time. So I believe that is on a Monday, with Rachel Ardeneau. And Rachel is an attorney who specializes in marijuana and cannabis cases, who's going to talk to us about the complete guide to jumpstarting your creative marketing mindset. So obviously, coming from an industry that I don't know, requires creative marketing, or certainly it can truly dovetail into it, I'm super excited to hear what Rachel has to share when it comes to that. Obviously, not all of us are cool enough to work in cannabis law, but I hope that we'll all be able to take some great insight from Rachel and apply it to more creative marketing from our own standpoint. With that, though, Ray and Sam, before I let y'all go, I want that final nugget of wisdom, that biggest takeaway. So it could be something we've talked about. It can be something totally different. But if somebody's been listening to this for the last 45 minutes or so, they remember nothing you said, what would be your biggest takeaway to help as many attorneys as possible become the Exhibit A of a successful lawyer?
Build out the non-economic damages for every single case with information provided to you by your client.
Love it. Ray?
Well, I was going to say, build processes that allow your team to collect the information you need to work up the case, because that's absolutely important. That very much in line with what Sam said, but that's what you got to do. We're seeing that's what attorneys mainly miss out on, and it's just because there's so much to do. So
yeah. Well, and the more you build that system, the easier it is for that system to scale with more clients, the easier it is for you to train another case manager to follow that system, or paralegal, or whatever it is, the easier growth becomes, as long as you are doing things consistently or automatically or with, even up, etc. All right.
yep.
So
Agreed.
thank you to everybody for listening and watching to this. Before I let you go, if you all love our conversations, you want more free tips and insight, and you want to connect with our guests better, we invite you over to our Facebook group, Solutions for Lawyers by Lawyers, Solutions for Lawyers by Lawyers on Facebook. Most of our guests are in there if you've got specific questions. We've also do spotlights of members in there, as well as monthly happy hours to get everybody together virtually and chat across the country. So thank you, everybody, for listening. We'll see you Monday for Rachel's conversation on creative marketing. Thank you for listening to this episode of Exhibit A Attorneys. If you're interested in becoming the Exhibit A of successful attorney, please check us out at legalesemarketing.com, EASE.